Earlier today, I spoke with the lead attorney in this case at his Minneapolis law firm. Where we're at today from what happened on Tuesday.
Right. We were a little bit overwhelmed by all the victims that stepped forward. In fact, we got over 50 declarations from victims who documented child protection abuses where their children and the parents were victimized. And so we saw that there was some more general problem statewide. And so the changes that occurred in the complaint and now in this letter we've sent to the judge is that we're seeking a statewide injunction against certain statutes that the child protection agencies follow. And the principal problem with the statutes is they regulate parental conduct. They don't protect children. And so when you have these standardless standards allowing child protection to grab children when parents are, maybe doing something that the child protection worker doesn't like, but isn't harming the child, it's unjustified. And these are the reports we're getting, and so we're bringing forward this claim based on victim reports. So, for example, the statutes allow for the child protection workers to take children away if the parent isn't providing care. Well, okay, but it should be care that's harming the child. There's another statute saying the parent isn't providing special care. Well, it should be care that's harming the child, or medical neglect, just as two words, and it should say medical neglect that's resulting in harm to the child. And so you end up in these situations where there's no harm to the child, but child protection is terminating parental rights. There's also the issue of corporal punishment, ordinary corporal punishment to correct or discipline a child. And the statutes on one hand say you can, the other hand say you can't, presenting the child protection worker's discretion to take children away, let's say from single parents who've done a single spanking, like in Dwight's case. And then 22 months of separation based on a single spanking. Also, with the permanent termination of parental rights, the standards are so standardless that one of the provisions says, well, we can terminate parental rights permanently if the out-of-home safety plan has not been satisfied. And so you have this sort of situation where, are you kidding me? You have to show harm to the child to permanently terminate parental rights. Otherwise, the government shouldn't be involved.
When you alluded to the signatures, the petitions, the 50 added petitioners on this, how long of a time frame are you talking about? I mean, you said that they had just come forward. So there are people who are hearing about this, and they're saying, me too.
Right, and so that was what was sort of overwhelming, because we took Dwight's case as a, wow, there's something wrong. But over the last 6 weeks, hundreds and hundreds and hundreds and hundreds of people have called us, and also the people reporting on the story. And we've been interviewing them. Dwight's been interviewing them. And we've been vetting their stories to make sure that they're victims of the process. And then these victim stories are being told, and we're analyzing them. And we see, two problems. One is structural flaws in the statutes. And there's a U.S. Court of Appeals opinion from the 8th Circuit, which governs our district, that says these statutes are subject to the strict scrutiny, which means they need to be narrowly tailored to meet a compelling state interest. So that means, based on the statute, that the government of Minnesota, child protection agencies, can't terminate parental rights without showing that some harm is being prevented to the child. And that's not happening statewide. And we think part of the motivation and why we've gone so far with these standardless statutes is that there's a money incentive for the county agencies in the states to take these children from parents, because the foster care is paid for, the child worker is paid for, the supervisor is paid for, even the judge is paid for, the county attorneys are paid for, everyone gets paid. But there's no harm being prevented to the child, so it shouldn't have happened at all. And that's what we're finding, and it's a real victimization, because when you separate a young child from a parent, there's a lot of psychological harm done. And the government's horrible at raising children. We all know that.
So you are saying, and in this, the outcome, the long run, as we look at the total outcome with all of this, Erick, you would like to see changes. You don't necessarily want to see Child Protective Services shut down.
That's right. Child Protection Services can no longer operate under these statutes.
Okay.
And so the effect of an injunction on Child Protection Services will be that all these statutes have to be thrown out, and new ones are going to have to be drafted, that are carefully tailored so that every termination of parental rights is justified by prevention of some harm to the child. And otherwise, the government has no business in interfering with a fit parent's relationship to their child. And what we're seeing in these victims are a fit parent, fit parent, fit parent, fit parent, child protection coming in based on some sort of notion that the parent didn't do something right, and then the child's gone. Or not even just the child, sometimes it's all the children, because they automatically take all the children if they take one. And it appears to be that they've aligned their programs up not to protect children, but to get the money. And so they're forgetting how much harm they cause to fit parents when they lose their children, because the child and the parent are affected.
Let's take a break here, because this is a good place to stop, and then when we come back, we can talk about maybe how broad these statutes really are, and you call them unconstitutional. Continuing our conversation now on the lawsuit that has been filed seeking changes to child protective services throughout Minnesota. It is a matter of what laws are currently in place and what Dwight and Erick would like to see happen. Here's more of our interview. Explain to me, as I have heard and read a lot of Dwight's claims, and within this lawsuit, the unconstitutionality. What does that mean?
Well, we just begin with something like simple, and that is an action to discipline a child or even protect a child. Like I saw a mother on Marshall Avenue in St. Paul. The child ran out in the street, and the young mother grabbed the child, pulled her back on the sidewalk, and then spanked her on the bottom a couple times. And then the child was screaming, but the mother assured her that it was done for her own safety. And so under the child protection laws we have, it defines malicious punishment assault are incorporated into the child protection laws, the CHIPS definition, child in need of protection services. And it basically says that you cause any pain to a child, any unwanted pain, that can be justification for terminating, at least on a temporary basis, parental rights. And so what we're saying is there needs to be protection for parents who correct and discipline children. There also needs to be protection on this other end with respect to sort of these neglect situations, because the statutes say, well, the parent has to provide required care, special care, has to provide, has to avoid medical neglect, but it's without a definition that requires a harm to the child. So what you're having is child protection grab parents for violating rules that have nothing to do with the interests of the child. And we're seeing that over and over again. So how do you justify in a single spanking, Dwight, first time spanker, so forth, a single spanking separating the child for 22 months? And then this other case where the mother had to take the young child out of the hospital and signed a document against medical advice when the child was fine. How does that end up being a child abuse case? So the medical record said the child's fine. She had to go before discharge, sign a document against medical advice, then child protection starts a case even though the child's fine, and then separates the child from the parent on a 72-hour basis, and then the case proceeds. But it's gotten out of hand.
Sure. Now, I have, on a personal level, dealt a lot with child protective services because I provided respite care in the foster care system. And having dealt with a lot of social workers who don't make a lot of money, and it doesn't seem like their departments are making much money, because I'm in Dodge County, which isn't a wealthy county. Counties I know are different. They're run a little bit differently in their services, right? How do you say that they're making money off of this? What are your claims that they are making money off of this? Because it doesn't seem like it. It doesn't look like that.
I'll have to answer that question.
Okay.
That is the information that I need to supply. I have their documentation that I will forward to you from Koppel, the assistant commissioner, telling them to bill because the billing funds the position and helps them grow their services. So this is coming from the assistant director saying to bill in their targeted case management system. So I'm going to forward you that document so you'll know, and he says it. It helps us fund your position. So the social workers' positions directly are contingent on them getting the children in so they can keep their positions and even grow the department and grow their services.
Erick, in court, are you going to use that then as part of your argument against the system?
Well, I don't think we have to go that far. I mean, we're going to tell the court that's what's driving it, but the point is the laws are unconstitutional. And, yeah, the money's there. It looks like it's a motivation. Like, we don't want police officers having a quota for tickets. We don't want child protection workers having a quota for kids. But in order to win our case, we don't have to prove that. That's not this type of case. This type of case is, if you read the statutes and you're a parent, you're like, this can't be the manual for taking my kid away, because it doesn't say anything about preventing harm to the child. And so, you know, when you see a child protection a set of statutes, you should see protect the child, but rather this set of statutes is about regulating parental conduct.
So this is more aimed then at the parents, and you want to see that changed to focus more on children who are victims.
That's right, and it's terrifying because think of the disorderly conduct statute. Sure, some meatheads get convicted, but the point is it's not supposed to be used to regulate manners of the ordinary person. And so here, yeah, child protection, yeah, of course they should get the abusers, of course they should get the violators, but they shouldn't be regulating the manners of fit parents by taking the children away. I mean, Dwight spanked them what?
Erick gave it an acronym. Instead of calling it Child Protection Services, Erick started saying, no, this is the determination of parental rights services. Because all of the statutes, and I think that's something good to say, all of the statutes are geared toward taking the child away.
Okay. And that's ultimately what you would like to see changed.
Well, that's the big systematic change. And then we have this case law from the U.S. Court of Appeals that says that these constitutional rights apply. So basically, a single parent has a right to have statutes that are narrowly tailored to meet a compelling state interest. And here, the government has no business interfering in the relationship between a child and the fit parent. And here we have all these statutes authorizing all this interference. And then the victims step forward, and it's the worst nightmare because the victims are saying, yeah, and we vetted him, I didn't do anything wrong. I checked my child who was well out of the hospital against medical advice, and the result is I lost my kids. I mean, that doesn't add up. 22-month separation on a single instance of disciplining or correcting a child. So all these victim stories are running in the same direction, that we have a horrific, statewide, systematic violation of constitutional rights. And it's a huge story, but the good part of it, with the victims coming in, and with the statutes saying what they say, is the court can issue a statewide injunction. It's a matter of doing business with the state agencies violating the law in a big way and having a big effect on lots of victims. And the court issues an injunction, then the legislature fixes the statutes, and we're back in business. But it is going to require a huge course correction on behalf of child protection and that culture. Now, with respect to those good social workers you mentioned,
yeah.
Call us. Come on, we know your stories. We know you live in the system, and we know you hate it. So if those child protection workers would contact us, that would be fantastic.
So I reached out to the Department of Human Services, of course, looking for an interview, not only regarding this lawsuit, but knowing that their procedures might keep them from commenting about current litigation. So I asked if Commissioner Emily Piper would at least talk to me about the good that comes out of Child Protective Services. There are so many children, we know this, who are ultimately taken out of legitimately abusive homes, and that is not what this is about. Commissioner Emily Piper respectfully declined an on-camera interview, but in a rare move, she did acknowledge this lawsuit and gave me a statement saying, every day, trained professionals in counties across Minnesota go to work to protect our children and families. To call their work kidnapping, as this group has done on social media, that is an affront to the extraordinary service they perform for all of us, particularly the most vulnerable children in our community. Our highest priority is keeping children safe, and Minnesota's child protection system is an integral part of that work. The state and Minnesota's 87 counties, which directly administer child protective services, are working to strengthen the system and address disparities. We continue to implement changes recommended by the Governor's Task Force on the Protection of Children, published in March 2015, with short and long-term steps for making improvements for Minnesota families. That is her entire statement. We did not edit anything out.